Okay, we've got somebody on the phone. Your last four digits are 1622. Can you tell me your name, please?
Callan House.
Your house. Okay, Mr. House, I'm just going to put you on hold for just a minute, all right?
Yes.
Okay, Ms. Kraus, I've got a couple people connected here that are just listed with device names, not their party names. So I'm trying to figure out who we actually have here. So just 1 minute. All right, looks like we have Mr. Bargy connected. So let's go on the record in that case. This is Ann Julia Brandow versus Robbie Bargy, case number 1415291. The record should reflect Mr. Bargy's present today by Zoom video. We had some proceedings last week in relation to custody parenting time. We're on the record here today regarding child support. So Ms. Kraus, can you give me an update about where we're at with the support issue on this case?
Yes, a bench warrant was issued on August 15th of this year for the defendant's failure to appear for a show cause. On August 20th, the defendant posted the $600 bond. This is the confinement only case. Friend of the court would request that the bond be released and applied to the defendant's account. Once the bond is applied and his recent payment of $127, the remaining balance would be $752. Therefore, we would ask for the show cause proceedings be dismissed once that's done.
All right, thank you. Mr. Bargy, were you able to hear that?
Yes.
Do you have any objection to what Ms. Kraus is suggesting for how we proceed?
No.
Okay. All right, so Ms. Kraus, the court will adopt your recommendation, and if you can prepare an order for that. And Mr. Bargy, do you have any other questions?
No.
Okay. All right, thank you. That's all for this hearing today, and you're free to disconnect at this time.
Okay, thank you.
All right, and we do have one individual connected on a Samsung device. Whoever that is, if you can unmute and turn on your camera, please. Sir, can you tell me your name?
My name's Timothy Brewer.
Timothy Brewer. Okay, Mr. Brewer, I have your hearing set for 9:45, so I'm just going to put you back in the waiting room until that time, okay?
Have a good morning, Your Honor.
Thank you. Okay, so Ms. Kraus, the only other show cause matter I had set was Katie Milne versus Leighton Gow, case number 0913256. I don't see either of those parties appearing here today. How did you want to proceed on that file?
Bench warrant issued on December 5th of 2022 for the defendant for failure to appear for a show cause. The defendant did post a bond on August 22nd in the amount of $600. The defendant has an obligation of $100 and a balance of $3,525.24. First, we would ask that the bond be released to friend of the court so it can be applied to the defendant's obligation and balance. And we would not be seeking contempt at this time, but we would request that this hearing be adjourned to the referee as there is a support review. But unfortunately, right now, we don't have a good address for him, so I'm not sure the outcome for that next hearing
Okay, all right.
on
So the
November
court,
20th,
that's when the hearing is set for?
please.
Okay, all right, so the court will order that the bond be released, and then we'll proceed as scheduled before the referee, and then depending on where that goes, we can schedule further following that. Did you have any other matters that we needed to address in terms of show cause today?
I don't. If it's all right, though, I would just stay in the courtroom for the other cases that are in front of you.
Yep, absolutely. I appreciate that in case we need your input, so thank you.
Yes, thank you.
Okay. Okay, let's see. Mr. Blumberg, do you have your client with you?
I do.
All right, so I have Vander Kerkhoff versus Vander Kerkhoff. This is case number 2419800. If I could have counsel put your appearances on.
Good morning, Your Honor. Elliot Blumberg on behalf of the plaintiff, who is appearing via Zoom from my office.
Reagan Richards, Legal Services of Northern Michigan, on behalf of Haley Van Diekerchove, who is the plaintiff. She's seated behind me.
Okay, I have this set for a pre-trial hearing today. Ms. Richards, on behalf of the plaintiff, can you tell me the status of this case and what you would like to see for scheduling going forward?
We have a mediation scheduled for next week. For custody, we'd like to add property division to that as well, if it's okay with Mr. Blumberg and Mr. Van Diekerchove. We also have plaintiff's domestic relations verified financial information form to be sent over to Mr. Blumberg today. I have not received that from defendant.
Ours is complete and ours will be sent to you today as well.
Okay, so do you want me to just kind of leave discovery open for a period of time, maybe 60 days, and set this for another status conference at the conclusion of that period?
That sounds good to me.
Judge, we need to get the marital home appraised. That's really the most significant asset of this marriage. We have a custody hearing coming up before the referee in November, so that issue is obviously still out there.
Okay. Do you want to move it out 90 days then, Mr. Blumberg, to address those issues?
I think that would be appropriate.
Ms. Richards, do you have any objection to that?
No objection to that, Your Honor.
Okay. All right, so the court will just order that parties to participate in mediation is currently scheduled, discovery to remain open for the next 90 days, and the court will set this for a status conference at that 90-day mark. Ms. Richards, anything else I can address for your side today?
No, Your Honor.
Mr. Blumberg?
No, Judge, thank you.
Okay, thank you. That's all for today, and both parties on this file are free to disconnect at this time.
Thank you, Your Honor.
I just wanted to double check.
Yeah.
I saw that and then I got my card and I said, "Crap, I forgot to-"
Let me just go through real quick.
Arraignment.
That'll be by Zoom, so we don't.
Oh, okay.
be in person.
Yeah, really fun to hang out
I'd like to.
with.
It looks like, yeah, 3:45, we have a PPO. That's in the in-person.
Was there the 2:30 that might have been in question that I was thinking about?
It doesn't say it, but yeah, that would be the division. Yeah. Jen might forgot to put it in there. It didn't come in. Okay. So, yeah, I think 345.
Sounds like a plan.
Okay, cool, thank you.
Yes, sir.
All right, Mr. House, are you still there?
Yes, sir.
Thank you. And Ms. House, if you can hear me, I just need you to turn on your camera and unmute, please.
I think it's all set.
Ms. House, are you there?
Yes, I am, sir.
Okay, great. All right, we'll go on the record. This is House versus House, case number 2419615. The record should reflect that both parties are connected remotely today for this hearing. Looks like there's already been some proceedings regarding custody and support in this case. The purpose of this hearing today is to determine whether or not the parties have any issues regarding the division of any marital assets or debts. And Mr. House, you're the plaintiff in this case. Are there any outstanding issues regarding the division of any property of the marriage?
No, sir.
All right, Ms. House, would you agree with that as well?
Yes, Your Honor.
Okay. All right, so, and do either of you have any objections regarding custody or support in this case that need to be heard by the referee or that are still pending?
No, sir.
No, Your Honor.
Okay. All right, so really all we have left to do then is just to enter the judgment of divorce in this case. And so that, Mr. House, you're the one who filed for divorce in this case. Did you get your documents and forms to file? Did you get that online?
I have it, yes, and I talked to Shasta last week. I went in and I filled it out incorrectly, but she gave me a new one to fill out and bring back to her.
Okay. All right, can you do that within the next couple of weeks here? Get that taken care of?
Absolutely. Absolutely.
All right, so what I'm gonna do then is set this for a final hearing at my next available date. So Mr. House, you'll need to get that form approved by the friend of the court. And then there's also another form called the judgment of divorce. Do you have that form?
Yes, sir.
Okay, so you'll need to fill that out and get that to the court. And you'll need to have both of those forms turned into the clerk's office downtown at the courthouse downtown prior to that next hearing. And then if I have those at that time, then we can finalize the divorce on that date, okay?
Okay.
Ms. House, do you have any objection to that?
No, that's fine, Your Honor.
Okay, so the court will send out the notice of date and time of that final hearing. It'll be remotely, just like we're doing today. And again, Mr. House, it's just important that you get those forms turned in ahead of that hearing so that we can go forward. Otherwise, we won't be able to finalize things on that date, okay?
Yes, sir.
Okay, thank you. That's all for today. Both sides are free to disconnect at this time.
Thank you.
Thank you.
Okay, Mr. Blumberg, do you have Ms. Glazier with you there at your office?
Yes, Judge, I do.
Okay, and Mr. Glazier, if you're able to hear me, I just need you to turn on your camera and unmute, please. All right, Mr. Glazier, are you able to hear me okay?
Yes, Your Honor.
All right, thank you. We're on the record now in Glazier versus Glazier. This is case number 2319311. The record should reflect that both parties are present today by Zoom video. This is set for a status conference in this case. And so, Mr. Blumberg, on behalf of plaintiff, can you tell me where things are at this point?
Yes, Judge, we can. The business evaluation of Mr. Glazier's business is not complete. We've partly because of the very sparsity of records that we were provided by his accountant, but we're still waiting for a preliminary evaluation of the value of his business. The business and the marital home are really the two major assets of this divorce. So once we get that, we can either return to mediation or schedule the matter for trial.
Do you have any thoughts on what the time frame would be for that?
I'm hoping within the next 30 days to at least have a preliminary report that I can show Mr. Glazier, and perhaps then we can talk about a way to resolve this matter.
All right, thank you. Mr. Glazier, is there anything that you wanted to add to that, or any other information that you'd like to provide today?
I guess Mr. Blumberg talked about the business and the home. I'd like to add that there is also a 401k of Beth Glazier's that's of interest as well.
Okay. All right. I guess, Mr. Blumberg, in terms of time frame for next hearing in this case, assuming that you can get a preliminary evaluation and that you and Mr. Glazier can have some discussions, either informally or through mediation, is 60 days enough time to accomplish that?
I believe it is, yes.
Okay, Mr. Glazier, do you have any objection to that time frame?
No, I mean, no, there sooner the better, but it is what it is.
Okay. All right, so the court will, I think we've already addressed mediation as part of an order and it has been referred. So I think it would just be getting the information and then setting a date for that. So the court will set this for a status conference in about 60 days. Mr. Blumberg, anything further that I can address for your side today?
No, Judge, I don't think so.
Mr. Glazier, anything else I can address for your side today?
No, Your Honor.
Okay. All right. Thank you. That's all for today. Both sides are free to disconnect on this file. All right, for the record, we did have another hearing set at 9:15, Heinz versus Heinz. This was case number 2419641. Whoever's connecting on the iPhone, if you can unmute, please.
How's that?
Hi. Good, good. Can you tell me your name, please?
Kylie Rosnowski.
Rosnowski, okay. I'm just gonna put you on hold for 1 second, all right?
Yep.
All right, so back to the Heinz matter, that was set for 9:15. It's now 9:25. Neither party has appeared on that. That was set for a final hearing today. The parties were to submit the judgment of divorce in front of the court documents. That hasn't been done. And again, neither party has appeared. The court will set this for one additional hearing in November. If neither party appears for that, the court may consider dismissing the case. Ms. Kraus, have you had any contact with either of those parties?
It does not believe so. It looks like the last information was an informational only recommendation that was mailed out along with the letter with information on how to submit the judgment of divorce.
Okay, all right, thank you. All right, looks like we've got everybody connected. We'll go on the record on our 9:30 hearing, which is Rosnowski versus Rosnowski, case number 2419659. If I could have both counsel put your appearances on, starting with plaintiff, please.
Jody Docket appearing on behalf of Scott Rosnowski.
Wanda Locher on behalf of Kylie Rosnowski, defendant.
Okay, we're on the record today for a status conference in this case. Looking at the file, it looks like the last time we met was back in June. The parties were going to participate in mediation and possibly have this set for a final hearing. Ms. Doak, on behalf of plaintiff, can you tell me where things are at from your side?
Yeah, we were not successful in reaching a resolution during mediation, so I think it's going to need to be set for a trial.
Okay, Ms. Locher?
Concur.
All right, Ms. Doak, can you just give me an idea of, from your side, what you view as the sticking points and the issues that will need to be addressed at the hearing, and how much time you think we need to set aside for evidentiary hearing?
Yes, sir. There's a marital home. There's issues of separate property and personal property. Parties do not have children, so there's no child custody issues. I don't believe there's any retirements or accounts that are retirement in nature or business interests. So I believe that because the other side, I think, is trying to present an issue that they're saying my client didn't contribute at all to the marital estate and therefore shouldn't get any part of the real estate. I think that's probably going to take more time and more evidence than would be typical. So I would ask for a day for both of us.
All right, thank you. Ms. Locher?
I think that is appropriate. We're not able to come to an agreement. And the issues that she cited are correct. And I think a day would be sufficient.
Okay, 1 day total or 1 day for each side?
I meant
each side.
I meant to say 1 day total is what I meant
Okay.
to say. But Ms. Locher, I think we were kind of speaking at the same time, accidentally said that she thought it would require 1 day for each side. Is that right, Ms. Locher?
Yes, I believe it would be one side. My evidence is going to have to be quite a bit more extensive to prove our theory of the case.
Okay. All right. So the court will set this for a 2-day evidentiary hearing. I think realistically, it's going to be 60 to 90 days out. Either of you have any objection to that time frame?
No, sir, that would be expected.
No, you're
Okay. All right. So the court will set this for a 2-day evidentiary hearing. Again, about 60 to 90 days out. I will request that both parties exchange witness and exhibit lists 14 days out, and that both sides provide the court with a trial brief 14 days prior to the hearing. In that trial brief, I'd like both sides to set forth what they believe to be the issues the court will need to determine at trial, as well as each of your proposed division of any assets or debts in the marriage. And again, I'll ask that you submit those to the court and exchange those along with the witness and exhibit list within 14 days prior to the trial date. If there are further discussions between the parties or any kind of resolution is reached prior to trial, I'll ask counsel to notify the court of that as soon as possible, because I can certainly use those days for a different hearing if for some reason you're able to reach an agreement prior to that. But I will send out a order that reflects the dates here that we've discussed, and then the court, of course, will send out notice of the date and time of that final hearing. The court will not set any hearings prior to that date, so our next hearing will be the bench trial date. Ms. Doak, any other scheduling matters I can address for your side today?
No, sir. Thank you very much.
Ms. Locher?
No, Your Honor, that's fine.
Okay, thank you. That's all for today, and all sides are free to disconnect on this file.
Thank you, Your Honor.
Ma'am, can you tell me your name, please?
Haley Jarneski.
Jarneski, okay.
Dad!
Mr. Cole, are you able to hear me okay?
Dad!
Yes, Judge. Can you hear me?
I can, thank you. All right, we're on the record now in Jarneski versus Brewer. This is case number 2419758. The record should reflect that all parties are connected at this time. This is the date and time set for entry of a default judgment of support. Mr. Rolla, I did have an opportunity to review the file as well as your proposed judgment. Was there anything that you wanted to state for the record today?
No, Judge, other than to ask the court, with the exception of perhaps taking some foundational information from Ms. Jaranowski, I think the court should, as all it needs to enter a default judgment.
All right, Ms. Jarneski, are you able to hear me okay?
Yes.
Okay, you are the mother of Timothy Ryan Brewer Jr., is that correct?
That is.
All right, and you understand that if the court enters this order today, it would provide for primary physical custody of the child with you. You would share joint legal custody with Mr. Brewer, and that parenting time would be for Mr. Brewer as provided in the order. Do you understand all of that?
Correct.
As a mother of Timothy Jr., do you believe that entering these orders today would be in your child's best interest?
Yes.
All right. Mr. Brewer, were you able to hear everything that I just said?
I did, but I was not under the understanding there was any parenting or any of that would be decided today. I didn't see none of that in the packet. I thought this was just regarding support. Kaylee had put in for child support, I think back in July when me and her were still living together, and she tried to cancel it and it didn't cancel for some reason. I mean, that's what I was told about this case from her.
Okay, so what
because we've always yes I can, Your Honor, I'm sorry.
Sure, the parenting time allows for it to be as the two of you agree,
which is week on, week off always.
Okay.
And is what I want to say, Your Honor. So we always agreed to week on, week off, and me and her separated September 1st, and she left him with me. I had him until that was a Monday. I had him until the next Monday. I returned him to her, and then she kept him for 3 weeks, and then she did give him back. So I just want to get the order of parenting time, figured out.
All right, well, what this order provides, and the two of you are free to make your own arrangements however you want. What the order provides is that parenting time would begin on Friday at 5 p.m. on Fridays at 5 p.m. and go to Sunday at 5 p.m.
No, absolutely not. I do not agree to that at all.
Judge, this is a default judgment. This is not something that's up to Mr. Brewer any longer.
Well, this was never brought to my attention. I did not know nothing about this.
All right. Well, Mr. Brewer, you were served with the complaint for this back on August 1st, and you didn't file any kind of answer to contest it at that time.
Okay, and I thought that's what this was me to contest it. So, okay, I guess I understand that.
Yeah, when you were served with the complaint, it explained to you the time frame that you had to file an answer if you were going to object to.
I guess in that complaint, Your Honor, does it say that every other weekend at 5 to 5 is what she was stating?
What, honey?
Well, she put in the complaint or her complaint that she went every other weekend is all I get them 5 to 5.
Yeah.
They've never been enough.
No, I know. That's what I'm saying. All right, Your Honor, I'm sorry.
That's all right. So Mr. Brewer, you have a couple different options. Number one, as I said, you and Ms. Jerneski are always free to make your own agreement on how to do parenting time, or you can file a motion with a friend of the court to have that modified if you'd like it to be different.
I have that filled out, Your Honor. I will do so today.
Okay. All right. Very good.
Thank you.
Okay. So that's all I have for today.
I have
All
some
part-
Can I have a minute to bring up some things that happened over the weekend that I have concerns about?
Well, it's not gonna be relevant to what we're doing here today.
Okay.
If may become relevant when you guys, if and when you have a motion to change that parenting time. So you'll have an opportunity to bring those up at that point.
Okay.
All right, Your Honor. Thank you.
Okay, thank you. All parties on this file are free to disconnect. Mr. Roll, the court will enter those orders as presented.
Very good. Thank you, Your Honor.
Oh, the weekend is all.
Ma'am, can you tell me what case you're signing in on today?
Roofs versus roofs.
Okay, I have that set for 10:45. So I can either put you in the waiting room or
Oh
you
my
can sign
goodness.
back in at that time.
I will sign back in at that time.
Okay, thank you.
Yep.
Sir, can you unmute yourself, please? And can you tell me what case you're signing in for?
Monica Peck versus Jordan Peck.
You know what time that was supposed to be?
Shows October 7, 10 a.m.
Yeah. And are you sure? I'm Judge Mertz. Are you sure it was in front of me in my court?
Yeah, the order I have right here says, has the true copy on it. It says Judge Mertz, October 7, 2024, 10 a.m. and then has the Zoom pin.
Okay, do you have a case number there that you can give me?
Yes, sir. Case number is 24-19760.
Okay, let me take a look on that. I don't have you on the docket, so let me see what we can find out and I'll bring you right back in, okay?
Yes, sir. Thank you.
Thanks. Mr. Pack, so there was a mistake in the docket, but we can take your case. So if you can just hold on 1 second, the clerk is going to grab your file, and then we'll start your case here in just a minute, okay?
Yes, sir. Thank you.
Thanks. Okay, let's see. Ms. Peck, if you can unmute, please. Thank you. All right, we're on the record now in Peck versus Peck. This is case number 2419760. The record should reflect that both parties are present here today by Zoom video. And let's see. This is set for a final hearing. I do have a proposed judgment that's been submitted by the parties. And so Ms. Peck, as the plaintiff, did you want to proceed with finalizing the divorce today?
Yes, Your Honor.
Okay, and Mr. Peck, is that how you'd like to proceed as well?
Yes, Your Honor.
Okay, so I'm going to place both of you under oath, and then I've got some questions that I need to ask each of you. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would please both raise your right hands. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Yes.
Thank you. You can lower your hands. Ms. Peck, as the filing party, most of my questions are going to be for you. Ms. Peck, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
In the complaint for divorce, in this judgment for divorce, you are not going to be receiving any spousal support or alimony. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And the judgment indicates that in terms of any personal property that the two of you have already divided that property up between the two of you. Is that correct?
Yes.
And same thing with any debts of the marriage. Is that correct?
Yes.
Okay. And that all of those things, as well as the real property, is going to be divided pursuant to the mediation agreement that the two of you reached back in July of this year. Is that correct?
Yes.
And are you agreeing to abide by that agreement?
Yes.
Okay. Thank you. Mr. Peck, did you hear all the questions that I asked Ms. Peck?
Yes.
And did you hear all of her answers?
Yes, I did.
Do you have any reason to believe that any of the answers that she gave were untrue?
No, I do not.
And under the judgment of divorce, you would also not be receiving any spousal support or alimony. You understand that you also would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
And are you agreeing to divide up any assets or debts of the marriage, including the real property, pursuant to that mediation agreement that I referenced earlier?
Yes.
Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court's reviewed the proposed judgment, finds that it's equitable and contains all the provisions required by statute and court rule. So the court will sign that judgment. So the divorce is final as of today's date. Ms. Peck, you are not asking to have your name changed. Is that correct?
That's correct.
All right. Ms. Peck, did you have any questions at all?
When can I get a copy of the judgment?
That'll be available for you to pick up anytime after 12 noon today from the clerk's office here in Gaylord.
Perfect. Thank you.
Mr. Peck, did you have any questions?
No, sir.
Okay, thank you. That concludes this hearing, and you're both free to disconnect at this time.
Thank you.
Thank you.
Mr. Bonamy, are you able to hear me okay?
Yes, sir, I am.
Okay, just 1 minute here. Okay, looks like we have everyone connected, so we'll go on the record. We have two matters to address today. We have People versus Casey Bonamy and Circuit Court File 216097 FH. And then we also have District Court File 2341550-SM-3. record should reflect that Mr. Bonamy is appearing today by video from the Otsego County Jail. We have Mr. Brown here present on behalf of Mr. Bonamy today. Mr. Brown, have you been appointed yet to either of these files?
I have been appointed to the circuit court file in the probation violation, and I believe Mr. Bruce may be appointed in the circuit court file.
Okay.
That's correct.
All right, and then we have Ms. Davis here on behalf of probation with regard to the circuit court file. Mr. Bonamy, you're before the court today, again, on the circuit court file for some alleged probation violations relating to your failure to appear back on August 15th of 2024, August 22nd of 2024, and a failure to report to your again, also on September 5th of 2024. Do you understand why you're before the court on that case?
Yes, I do. Yes, I do understand that.
And then in the district court file, you're here because you failed to appear back on August 29th of 2024. Do you understand that?
Yes.
Okay. Mr. Brown, I know this just came up this morning. Have you had any kind of opportunity to speak with Mr. Bonamy yet today?
I did have a very brief opportunity to speak to him. I was unaware of the particular allegations here. I did have a little bit of trouble trying to get the paperwork. I just received it about 2 minutes ago. I'm kind of browsing through it right now, but I did have an opportunity to speak with him.
You want more time to do that before we go forward this morning? I can put you in a breakout room.
I don't think I will need more time. Looking at the dates that you mentioned and having a conversation with Mr. Bonamy earlier, I believe we should be able to proceed.
Okay. All right. How does Mr. Bonamy want to plead today to these violations as to both the district court and the circuit court?
At this time, Your Honor, we would ask court to enter a not guilty plea and set the matter for a hearing. Based on my conversations with Mr. Bonamy, there is some documentation that he is going to need to provide, and that may give me and Mr. Trush a better understanding of how to proceed.
May I speak?
You can, but I want to warn you, and your attorney may do this as well. Anything that you say here, Mr. Bonamy, can be used against you. So you should be very careful about if you're going to talk about the specific facts of why you didn't appear, because that could be used against you later. So I'm just going to caution you, but otherwise, yeah, go ahead.
Okay, so I was working on my mental and physical health.
Okay, Mr. Bonamy, I think you're going to get into the facts here is what it sounds like.
No, I turned myself in just so that is known. I turned myself in 3 different counties. I just want that to be a fact, and I want that to be known. I handled it the best I could, and I turned myself in. Like I said, I would. I was not trying to abscond. I was trying to fix me and then handle it.
All right. Okay. All right. So the court will enter not guilty pleas on behalf of Mr. Bonamy, both with regard to the circuit court file and the district court file. And in terms of the district court file, I'm going to defer to Judge Cooper as to when he or his staff can set that matter for a hearing. In terms of bond, though, pending hearings in either court, Ms. Davis, do you have any recommendations?
Bond that you set for Mr. Bonamy was a $50,000 cash surety bond. When he did post it, he failed to report. So I'm just going to ask again for another high cash surety bond. And again, instruct Mr. Bonamy that if he does post bond, that he needs to report as directed.
Thank you. Mr. Brown?
Hey, Your Honor, there are some underlying issues here, which I won't go into on the record. And again, those are some of the issues that I'm waiting for some documentation from Mr. Bonamy to corroborate here. He does obviously have some severe mental health issues. He is on current medications, which I believe he is stating that he is not getting at the moment, which are not going to be very well for him or anyone involved for that matter. I don't want to get too much into the case here, but I would ask the court to take those things into consideration. Once I get that documentation and information, again, have a much better understanding of the failures to appear and if there was a good cause for those, but he does suffer from severe mental health indication or issues. So I would ask the court to take that into consideration when setting a bond in this matter. He does appear to be doing better. Court's well aware he's had drug issues in the past. He does report to me that he's been sober for about 63 days.
She's gonna have 4 days today. Can I ask, is there any way we could not set the bond so high and maybe we work out and I wear a GPS tether?
That may be something that could be worked out later, Mr. Bonamy, but at this point, you know, this has become a pattern of an issue for you where
Health, man.
Yeah, I get it, but we need to make sure that you're available for the hearing so that we can move forward with your case. And it's really in your best interest as well. The longer this drags out, the worse that it is for you, and the longer it's going to take where we can get you into a place where maybe you can have some stability and get the kind of help that you need. But we're on this kind of merry-go-round of you get arrested, you post bond, you disappear for a while, we get a hold of you a few months later, you're arrested on a bench warrant, you post bond, then you disappear again, and it's just this revolving door that it's not doing you any good, certainly, and it's a problem for the court in terms of proceeding with your case. So the court's
I
going to say,
understand. I've been in and out of hospitals and rehabs for a year, and I've been working on it, and like I followed it to the T. What I was instructed to do was to go get help, get sober, get my medications, and turn myself in. That is exactly what I did. It took longer than I expected.
yeah, there's no reason why you can't get help and get sober and still appear for your court hearings. Those two things don't have to happen separately. And while you may be doing one of them, you're not doing the other. And so I'm in a position where I have to make sure that you're going to do the other. And the way that I can do that is by imposing a high bond. And so the court's going to set bond in the amount of $100,000 cash or surety on the circuit court file, and $25,000 cash or surety on the district court file. And then again, the court will set this for a hearing at its next available date. And between now and then, Mr. Bonamy, you'll have an opportunity to speak with your attorneys, and I'm sure Ms. Davis will probably be in touch with you in the jail as well regarding the probation. The court will send out notice of the date and time of those hearings. And that's all for this hearing today. All parties are free to disconnect at this time.
Thank you.
All right, Mr. Morrison, are you able to hear me okay?
Yes, I am.
All right, we're on the record in Morrison versus Morrison. This is case number 23-19363. The record should reflect that Mr. Morrison is present today by Zoom video. This hearing was set for 10:15. It's now almost 10:20 by my clock. We do not see Ms. Morrison joining the hearing today. Mr. Morrison, we're on the record here today for a hearing regarding paternity. This has been an ongoing issue for a number of months now. You're asking the court to find that the child in this case, and when I say child, I mean the newest child, not your daughter. That child was born out of wedlock, and that you are not the father, so that we can proceed with the divorce case. Is that correct?
That is correct, sir.
All right. Ms. Kraus, are you there? I just want to check in with you to see if you had any contact from Ms. Morrison, or if you have any additional information regarding this case.
No contact, and the only information that we've seen is just that this hearing was rescheduled in front of you this morning.
Okay, so Mr. Morrison, the next step in this process is for the court to conduct a genetic testing. I'm going to issue an order that requires that you and Ms. Morrison and the alleged father in this case, who is Mr. Dunlap, is that correct?
That's correct.
Okay, that all three of you participate in the testing, which means that you and Mr. Dunlap would each have to give a sample along with the child. And once the court receives the results of that, which I anticipate based on your filing is going to show that Mr. Dunlap is the father.
Mm-hmm.
But once we have that established by genetic testing, the court can hold a final hearing and determine that the child resulted from out of wedlock, and then we can finalize your divorce. Do you have any questions about that process?
I do. As far as the payment for the genetic testing goes, who is doing the payment? Per person for their own, or is it? Because what I was told from Melissa, the reason she didn't want to do genetic testing was because, well, she doesn't want to have to make me pay for it, because I would have to pay for it by law or something. But I didn't have a child out of wedlock. I had to file all this paperwork by myself because she failed to do it multiple times, and I'm really getting tired of picking up the slack here. And I just kind of want to move forward with this. Who's paying for that? I'm curious.
So in the order, I'm going to provide that each party has to bear the cost of their own testing. So you would only have to pay for yours, Mr. Dunlap, and Ms. Morrison will have to pay for the child's testing, and Mr. Dunlap for his testing. And that I'm gonna prepare an order today that is going to explain that process of who pays for what. So it'll be in writing so everybody can see it.
Okay, perfect.
Did you have any other questions?
No, not as of this moment right now.
And that order is also gonna provide a cutoff date, a date that has to be done by, so that everybody understands that this isn't just you decide when you want to go, so they can't drag their feet. They're going to be required to participate, and if they don't, then they'll be subject to the contempt sanctions of the court.
All right, perfect.
Okay. All right, so the court will issue that order today. You'll get a copy of that, Mr. Morrison, as well as the other parties. Go forward from there. Ms. Kraus, anything further that you needed to add?
No, I don't believe after that's done, then we would still need to review the judgment of divorce before they file it.
Correct. Yeah. Okay. All right. Thank you. That's all for today. Mr. Morrison, you're free to disconnect at this time.
All right. Thank you very much. Have a great day.
Thank you. right, Ms. Almacher, are you able to hear me okay?
Yes.
And Mr. Almacher, are you able to hear me okay?
Yeah.
All right, we're on the record now in Almacher versus Almacher, case number 2419629. Record should reflect that both parties are present today by Zoom video. This is the date and time set for a final hearing in this matter. I am in receipt of a judgment of divorce. Ms. Almacher, did you want to proceed with finalizing things today?
Yes.
And Mr. Almacher, is that how you wanted to proceed as well?
Correct.
Okay, so I'm going to place both of you under oath, and I'm going to ask each of you a series of questions. The questions that I'm going to be asking each of you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would please both raise your right hands. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. You can lower your hand. Ms. Almacher, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
When I filed, I was living in Mansalona when I filed.
Okay. Have you been living in Otsego County for the last 10 days? As of this time?
No.
All right. Mr. Almacher, have you lived in Otsego County for at least 10 days during the pendency of this divorce?
Yes.
Okay. All right. Ms. Almacher, in the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
And there's one minor child born of the marriage, correct?
Yes.
And as part of the divorce, you and Mr. Almacher will share joint legal and physical custody of your child. Is that your understanding?
Yes.
And that you both have opted out of the friend of the court services and that neither of you is going to pay the other any amount of child support. Is that your understanding as well?
Yes.
All right. And then in terms of the assets or debts of the marriage, you and Mr. Almacher have agreed on how to divide up any assets or debts of the marriage, and there remain no issues for the court to decide. Is that correct?
Yes.
And as part of this divorce, you are not going to be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And are you asking to have your last name changed?
No.
All right, thank you. Mr. Almacher, have you heard all the questions that I asked Ms. Almacher?
Yes, I did.
Have you heard all of her answers?
Yes, I did.
Do you have any reason to believe that any of the answers that she gave were untrue?
No.
Do you agree with the provisions of the judgment that indicate you will share joint legal and physical custody of your child with Ms. Almacher?
Yes.
And do you agree that the two of you have opted out of the friend of the court services and that neither of you is going to pay the other any amounts for child support?
Yes.
And Mr. Almacher, do you agree that you and Ms. Almacher have divided up all the assets and debts of the marriage and that there remains no issues for the court to decide?
Correct.
And you also will not be receiving any alimony or spousal support. You understand that you also would be waiving that forever and could not come back later and ask the court for that.
Yes.
All right, thank you. Ms. Almacher, one question I forgot to ask. Are you currently pregnant?
No.
Sorry. Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties in this case. I've reviewed the proposed judgment and find that it's equitable and contains all the provisions required by statute. The court will grant the divorce and I sign that judgment. Ms. Almacher, do you have any questions?
No.
Mr. Almacher, do you have any questions?
No, I did not.
Okay, thank you. That's all for today, and you're both free to disconnect at this time. Okay, let's see. It's like we have both counsel connected, so we'll go on the record. This is Roos versus Roos, case number 1716694. And Ms. Pilarski, you're appearing on behalf of Ms. Roos, is that correct?
Yes. Well, I'm the same person. I got remarried.
Oh, all right, thank you. And Mr. Blumberg, you're appearing on behalf of Mr. Roos today?
Yes, Judge, he's here appearing via Zoom from my office.
All right, so this is set for a scheduling conference on Mr. Blumberg, your motion to change custody. I had a chance to review your motion. And this is before the court today based on the referees need to DQ from the case. So that's why we didn't go through the front of the court step here. Are you asking the court to just go ahead and set this for an evidentiary hearing? Did you want to attempt any type of mediation in this case to come to an agreement?
Judge, I would normally say, sure, let's do that. But I think the parties have such polarizing views on this issue that I think that would probably be a waste of everybody's time. So obviously, if you order us, we'll go there in good faith. But I think what we need is a hearing in front of you on this issue.
All right. How much time do you think we would need to set aside for that hearing?
I think one day would be sufficient.
Okay. Ms. Pilarski, are you going to represent yourself for this hearing?
Yes.
Okay. And do you believe one day would be enough time for the court to hear the evidence?
I think so.
Okay. Mr. Blumberg, do you need any particular period of time to be prepared to go forward?
I think it probably would be helpful if the parties could file a witness list, just so we get a better idea of how much time. I'm assuming we can do it in a day, but maybe if are we looking perhaps more than 30 days out, Judge, before we could get a date?
Yeah, I'm thinking it'd be probably 60 to 90 days.
Okay. If we could just be required to file a witness list within 30 days of the hearing, that would be sufficient.
Ms. Pilarski, do you have any objection to that time frame?
No.
Okay, so the court will set this for a one-day evidentiary hearing on defendant's motion. The court will order that both sides exchange witness lists 30 days prior to that hearing. So Ms. Pilarski, that just means that 30 days prior to the hearing, and the court will send you the date of that hearing, but 30 days prior to that time, you need to notify Mr. Blumberg's office of who you would intend to call as witnesses, okay?
Okay.
And then Mr. Blumberg will do the same, and you'll get a copy of that so that you know what witnesses they're gonna call. And then, as I said, the court will send out notice of the date and time of that hearing. Mr. Blumberg, anything else we can address for your side today?
I don't think so, Judge. Thank you.
Ms. Pilarski, do you have any questions at all?
Just, is that hearing in person?
Yes, it will be an in-person hearing.
Okay. And then do you happen to know like how soon before the hearing will I know when the date is? Just so I can make sure that I arrange stuff.
I think within the next 7 to 14 days, you should get the notice of when that hearing will be. So that you'll know when the hearing is relatively quickly.
Okay. Thank you.
Okay. All right. Thank you. That's all for today. All parties in this case are free to disconnect at this time. Okay, if I could have both of you on mute, please. Let's see, sir, are you Mr. Barry, Ethan Barry?
Yes, sir.
All right, and then ma'am, on the Samsung device, can you tell me your name, please?
Amaya Sherman.
You're, okay. Amaya Sherman. Okay, Ms. Sherman, I have your hearing at 11:15, so I'm gonna put you back on hold until then, okay?
Me?
No, Ms. Sherman.
Oh, okay.
All right, so Mr. Berry, this is file number 2419739. Mr. Berry's connected today by Zoom video. This was set for 11 o'clock. It's now shortly after 11. I don't see Miss Alexander in the waiting room. Mr. Berry, this is your motion to modify, extend, or terminate a personal protection order in this case.
Yes, sir.
What are you asking the court to change about the order that we have here?
To modify the PPO to where she can't post about me or like on social media. So there's been all the time she continuously defames my character by posting me and my personal things on social media. I had a mediation a while ago, a few weeks ago, and she posted that on mediation. My mediation agreement. She posted that on social media. I attached pictures on the paperwork, but they're like all videos, but that's just the best I could do to send in. But yeah, it's just I just feel like it's harassment at this point.
Okay. All right. Well, I did review your motion. I saw the post that you attached to that. I think, you know, what you're asking for is a reasonable request, given the circumstances. The court did grant you an order back in June prohibiting contact by her, and she hasn't challenged that order in any way. Again, she failed to appear for the hearing today. And it does appear that she was served back on September 25th with the notice of the date time of today's hearing, so she knows about this hearing.
Yes, sir.
So for those reasons, the court will grant your request for modification. I'll issue an amended order that reflects that she's not to post to social media or otherwise any information either directly or indirectly about you, okay?
So if she does, I just call the sheriff's department.
Correct.
Okay, and that starts today.
Yep, I'll issue that order today and I'll sign it with today's date. If you want to get a copy of that, you can get that from the clerk's office here in Gaylord. It's probably a good idea to get a copy of that for your records. Do you have any questions at all?
Nope, that was it.
Okay. All right. Thank you. Again, it'll probably be after lunchtime before I can get that order signed. Okay. So anytime after that, you can get it from the clerk's office and you're free to disconnect at this time.
Thank you.
Thank you. All right, Ms. Sherman, are you able to hear me okay?
Yes.
All right, we're on the record now in Sherman versus Hatley. This is case number 2419636. The record should reflect that Ms. Sherman is present by Zoom video. I see Mr. Hatley is also connected by video as well. Ms. Sherman, the court issued a personal protection order on your behalf back in March, and you filed this motion to have that terminated. Is that correct?
Yes.
Okay. Can you just kind of tell me why you don't believe this order needs to stay in place anymore?
I am currently 8 months pregnant, and I was just wanting to see if maybe it could be an option if he would want to try to work on things with him. I think what had happened was we're both teen parents. We were both scared. We both didn't know what we were going to do. So I did what I thought was best in my option. We were both scared, and I put the PPO out. I'm literally a month away from being due.
Okay. Are you worried that the circumstances that caused you to get the personal protection order in the first place might happen again?
No.
Okay. Obviously, my concern, Ms. Sherman, is a lot of times people feel pressure to have a personal protection order terminated. You know, they're worried about the effect it has on the other person, or maybe family and friends are putting pressure on them to have it terminated. And I just want to make sure that that's not what's happening in your case.
No.
Okay. All right. So based on your statements here, for the record today, the court will terminate the personal protection order. I'll sign that today. So by the end of the day today, that will be terminated. And that will allow you to have contact with Mr. Hatley and vice versa. Do you have any questions about that?
Nope, that's all.
Okay. Mr. Hatley, you can unmute. Do you have any questions at all?
No, sir.
Okay. All right. Thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Morning,
Mr.
Judge.
Smith, are you okay?
I can see and hear everything. Good morning.
All right, great. Good morning. We're on the record now in Lansing Area Federal Credit Union versus Hughes. This is file number 2319369. Hold on one second here. I just had another party pop up here in the waiting room. I'm going to see if this is Miss Hughes. Okay, for the record, party that popped up briefly in the Zoom waiting room was signed in under Alex Borden, which is a different name than the defendant in this case. So I don't know if that was related or not. Be that as it may, they've now exited, so they're no longer here. Mr. Smith, you're appearing here on behalf of the credit union, correct?
I am LAFCU Credit Union.
All right, so this has been a process. You've been trying to get some discovery, I think, to collect on a judgment. Ms. Hughes failed to appear previously, so we issued a show cause. I do know the file indicates that she was personally served back on September 17th with notice of the date and time of today's hearing. Again, she has failed to appear today. Have you had any contact with her at all, Mr. Smith?
I have not, Your Honor. There's been no
All
word.
right, so the next step obviously would be issuing a bench warrant. Is that how you wanted to go forward?
It is, Your Honor. We can prepare and submit that for bond consideration purposes. The balance on the judgment, $34,728.63.
Okay. All right. Based on her failure to appear despite being properly served, the court finds that at this point a bench warrant would be appropriate. So once you present that, Mr. Smith, the court will sign it, and then we'll proceed further once Ms. Hughes is brought before the court.
Okay. Would you like us to leave the bond amount open for your consideration, or is there an amount you'd like us to put into the warrant we're submitting?
No, if you can leave that open and the court will insert an appropriate bond amount and we'll go from there.
Okay, we'll prepare and submit. Thank you, Your Honor.
Thank you. Anything further for the record today?
Nothing, Your Honor.
Okay, thank you. You're free to disconnect. And that concludes the court's morning docket. The court will be in recess until 1:30.